So, hello and welcome. My name is Danielle Forrest, and I'm an alien romance author and YouTuber. And today I'm going to be talking about some of the more recent uh, rulings on AI, specifically the Meta case and the Anthropic case. And the reason I'm talking about this is because it does have some sort of impact on the book industry and authors and readers. And so I do think it's something that a lot of us are just really paying attention to and really invested in what this actually means for books in the future. So let's get started with that. I'll just switch over to this. All right. So I wanted to start out by talking about what is fair use, since that is where, these generative AI companies are putting all of their defense. They are trying to claim that it is fair use. This is a doctrine predominantly in the United States, lesser so in other countries. Like the UK does apparently have rules with regard to fair use, but it's more strict than in the United States. So, like some of these rulings that I'm going to talk about today, um, there has been commentary that I read while preparing for this video that kind of indicated that this wouldn't be as significant for them just because, obviously, um, the standards are different where they are. Anyway, so let's get started. So here is the copyright.gov site and all about fair use. And I wanted to go over these are the things that, kind of things that we're going to be talking about in this video. And I want to stress that this is a legal defense. So it says fair use. Like if you look right here, it says fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyright protected works in certain circumstances. Now, I want to stress that all of the links to articles and stuff I'll be referencing are in the description of the video. So if you want to go to these sites yourself, you can do so that way. Um, just FYI. And so like the cases, the indicate the I can't talk. It's been a while since the last time I live streamed. I'm sorry. There's four elements that are listed on the copyright website. The first is the purpose and character of the use, including whether it is used for a commercial nature or is a nonprofit educational purposes. So this is something that I think is largely getting ignored in a lot of these situations. And that's something I'll be getting into later. So in here, it says courts look at how the party claiming fair use is using the copyrighted work and are more likely to find that nonprofit educational and non-commercial uses are fair. This does not mean, however, that all nonprofit educational and commercial uses are fair and all commercial uses are not fair. Instead, courts will balance the purpose and character of the use against the other factors below. Additionally, transformative uses are more likely to be considered fair. This is another thing that is mentioned repeatedly throughout these cases is the concept of transformative, and it's specifically important for the Anthropic case. Transformative uses are those that add something new with a further purpose or different character and do not substitute for the original use of the work. All right, second one. Nature of the copyrighted work. This factor analyzes the degree to which the work that was used relates to the copyright's purpose of encouraging creative expression. This is another thing that's mentioned with these generative AI companies claiming that it encourages creative expression. And it's clear that they're trying to lean into this specific part of fair use, encouraging creative expression, which I think is kind of debatable considering the fact that a lot of people who are using generative AI are just not being creative. They're actually not, they're avoiding the creative part by using generative AI. So I'm a little sus about that argument. Just a twinge. Thus, using a more creative or imaginative work, such as a novel, movie, or song, is less likely to support a claim of fair use than using a factual work, such as a technical article or news item. And this is another thing I think is really important, is the fact that a lot of the things that are being used are fiction. They are more creative um, works rather than factual, textual, academic, etc. So that's another problem that we're encountering, is the fact that these are not the types of things that are usually more permissible. In addition, use of an unpublished work is less likely to be considered fair. That's the only part of this that I don't think is really relevant in across the board. Is I don't think we have any situations where we're really dealing with things that are just not published yet. The third point, amount sorry, amount and substantiality of the portion used in relation to the copyrighted work as a whole. This is where we usually get into like reviews and stuff, or using little clips of images, videos, etc. in like reviews of movies or something like that, or talking about the elements of a movie, etc. Those are usually considered fair use because they don't use the entire thing. And a lot of times, in order to get away from even YouTube being super careful about it, they end up you know doing very, very, very small bits of it, which, yeah. But the thing is, this one is probably the least relevant point, is number 3, just because they're not using portions. They're using the entire things. They're feeding entire books into their training models. And so this is like the least relevant point. But it does say that some courts, and it does say here, some courts have found use of an entire work to be fair under certain circumstances. So, this is something that's really not that terribly relevant for the most part in these cases. And the last is one that's going to be stressed a lot when I'm talking about the meta case, which is the effect of the use upon potential market for or value of the copyrighted work. And this is probably the part that's the most important when it comes to evaluating these cases for judges. They're specifically looking to see if this is going to have a negative impact on the work, on the copyright holder. Like, is it competing? Is it affecting their bottom line? Is it making it so that they can't make a living? And like this specifically says, here courts review whether and to what extent the unlicensed use harms the existing or future market. And this is literally on the copyright page, harms the existing or future market for the copyright owner's original work. It's not saying, it's saying the market itself harms the market. That is not stating that it's like directly, like that it's directly about selling that specific book. It's about the effect on the market itself, which is an interesting thing that I'd never really paid attention to before. And I think that this is something where the market dilution theory is going to come in more into play. Is this literally says this on the copyright website, which this is from apparently Section 107 of the Copyright Act. So this is something that's like in law. Further, it says, in assessing this factor, courts consider whether the use is hurting the current market for the original work. Again, current market. So it's not talking about whether or not the work is selling less. It's talking about the market itself, which I find interesting because I think this is significant. Because I think this makes it so that you could argue, hey, look at all of these books that are making it harder to market my own. That is a component. And this says, for example, by displacing sales of the original. Now, this is the most common, the most straightforward thing is you're buying this copy or downloading this copy for free when you could be buying from the author or downloading from the author. And or whether the use could cause substantial harm if it were to become widespread. And this is something I'm probably going to get into a little bit later when it comes to the Anthropic case. But we'll get into that. Anyway, so that is fair use, basically, these 4 components. And this is, these are the things that, these AI companies are generally using to try to argue that they are fair use. Now, the first thing I wanted to note is like, okay, so I had heard about the Anthropic case earlier, but I heard about the Meta case on Friday when I received an email from one of the organizations that I have signed up for a newsletter for. And so of course, the first thing I did was do a search. And the thing I found kind of striking right from the very start is that there's kind of weird narratives, like when I look at this. So like The Guardian says Meta wins AI copyright lawsuit as U.S. judge rules against, and I think if I remember, rules against the authors. Versus this one, Meta wins blockbuster AI copyright case, but there's a catch or something. But there's a catch, yes, that's right. Meta fends off authors' U.S. copyright lawsuit over AI. Anthropic, Meta, fair use rulings in AI expose. Where is that one? Judicial split on market harms. Meta wins AI copyright case. Judge welcomes others to bring. I don't remember what that one said. But like across the board, you're having these like really wide divides. Like some of them are just like simping for AI, and like even some of these that like are saying, "Oh, Meta wins AI copyright lawsuit." It's not that simple. Like even in this one, which I think that's this one here, you literally have a quote right here that I have highlighted. This ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. This is what the judge in that case actually said. They're literally like, yes, I have to rule in Meta's favor, but I don't want to. And this is it by no way a claim that I side with them. I just can't rule in the plaintiff's favor. And I think this is an important thing to recognize when it comes to copyright lawsuits and as a rule, is simply the fact that they're kind of piecemeal. So when they do go to court, generally speaking, the judge in question is like looking at all of these components of fair use and kind of looking at, does this fall into the spirit of the law, more than like any sort of hard and fast framework, because it doesn't have a hard and fast framework. As we were talking about when we were looking at this, there are situations where it said, this does not mean, however, that all nonprofit education and commercial uses are fair and all commercial uses are not fair. So you have these types of distinctions when it comes to, fair use, that like in theory it could look the same, but different judges are going to rule different ways depending on how they weigh different components of the case. Which is why you have what looks on its surface to be drastically different rulings in the Anthropic versus the Meta case, and I'm not sure it is. Additionally, I'm not sure either of them is a real win for AI, although I will say that I have some serious concerns about the Anthropic ruling for copyright as a whole. I think it could potentially cause some major ramifications for the indie industry specifically, because of the fact that it is basically stating that print books are fair game. But anyway, let's get into the Meta case in a little bit more detail. So this is the Wired article. Meta wins blockbuster AI copyright case, but there's a catch. And even here, where they are saying, but there's a catch, they're also calling it a blockbuster AI copyright case that they're winning. But I don't know that that really applies, because this case specifically is something that I would say is very dangerous for AI. Did they win? Yes. But even the judge in this case is stating specifically that Meta didn't win on the merits of the case. And that's paraphrasing, but it's specifically encouraging other authors to file lawsuits, that this does not constitute a win for AI. Because like I had in this here, this ruling does not, and this is the Guardian article. This ruling does not stand for the proposition that Meta's use of copyrighted material to train its language models is lawful. So it's specifically stating in the ruling that it's not stating that Meta lawfully used copyrighted material. Instead, the ruling is largely about the fact that the authors in question just didn't do a good job of arguing their case. They didn't make the right arguments, and they didn't provide the right evidence. And I just think it's funny that that's like, it's calling it this blockbuster win, this major victory in a copyright lawsuit. And I also think it's interesting that this was only 13 authors. Because you have other cases that are going through the courts right now. I think there's an Authors Guild case, for example, that is a class action lawsuit. I think the Anthropic one is a class action lawsuit. I don't know if that's one and the same. I haven't really paid attention to those components. But keep a note of this. The court has no choice but to grant summary judgment to Meta on the plaintiff's claim that the company violated copyright law by training its models with their books. This is what the judge said. Now, I want to double check, because I am not a lawyer. Summary judgment. And sorry if you're getting some ASMR from my keyboard. As I did, is a judgment entered by a court for one party and against another party without a full trial. That is, so basically, this is something that happens. So here's again, in Bloomberg law here, it's saying a motion of summary judgment does not allow the court to decide issues of fact, but to examine the pleadings and proof to determine if a trial is necessary. So basically, this is a situation where Meta didn't have to defend themselves. Instead, the judge took a look at the preliminary information and said, sorry, I don't think this is going to win on the merits of the case. I don't think that you really have a case. You're not arguing adequately. And they just it's like basically dismissing it. And I think calling this a win is, to me, this is kind of like saying, say someone was accused of killing someone, and the prosecutor brings them up on charges of first-degree murder. But then they get acquitted. But the thing is, the prosecutor didn't bring them up on any other charges, just first-degree murder. Well, you can't say then that they couldn't have been convicted of second-degree murder or manslaughter or any other forms of killing someone under the law, because they weren't actually tried for those things. And that's the thing with this. Claiming that this is a win is weird because they were never actually tried. This was just somebody brought a bad lawsuit and basically it just got dismissed. That's essentially what summary judgment is. I don't think it's exactly like the case was dismissed. I think it's slightly different, but it's just, this is over and done. You didn't provide enough evidence. You didn't make the right arguments. And so calling it a win is a little bit weird, honestly. I at least to my thoughts. Obviously, like I said, I'm not a lawyer, so if you are a lawyer in the chat or the comments, feel free to chime in a little bit. I would love to hear that. So this is saying it's one of the first cases of its kind. which, I mean, realistically speaking, it got shut down so quickly that having a ruling on it makes sense. It would be one of the first. This just has not had a trial. It's possible it hasn't even had discovery. I haven't read anything about it having a discovery case section, because that's usually one of the first things after they decide whether or not the lawsuit has merit, is they'll do discovery when it's going to trial. But this didn't happen in this case, I'm assuming because it had summary judgment. And the judge in this question, which I am not going to pronounce his name or their name, I don't know if it's a man or a woman or a non-binary person, had previously stressed that he planned to look carefully at whether the plaintiffs had enough evidence to show that Meta's use of their work would hurt them financially. And this is a quote: "The key question in virtually any case where a defendant has copied someone's original work without permission is whether allowing people to engage in that sort of conduct would substantially diminish the market for the original," he wrote in the judgment on Wednesday, which is true. It's very fair. That's actually quite accurate. That is kind of the whole point of copyright law, is to protect a person's livelihood. So this makes sense that this judge would make that specific distinction. And it briefly talks about the Anthropic case, saying that Judge Alsup ruled that Anthropic's use of copyrighted materials to train its own AI tools was legal. This I find interesting because that's completely inaccurate. That's not what they ruled. They ruled that a very specific portion was allowable under copyright, specifically related to a Google case from, I think, 2013, using that as precedent. And I do want to talk about that. I am going to be talking about that a little bit later. But that's not what they ruled, because they also allowed the case to go forward, because Anthropic did not just use destructive scanning to in their use of copyrighted works. They also created a database essentially of pirated copies. So that's really inaccurate. And then they even go on to say, like, it was a split decision, as the AI company will have to face the plaintiffs in court for pirating their books. So that's kind of like, why would you say it this way? You're literally, like, the whole point, like, this is just weird. And this is some of the things I'm seeing is this, like you could very easily say, you like clip this specific thing and use that as justification that generative AI is legal. It's fine. They're not doing anything wrong because this judge said so. But, like, that's literally not what the judge said. I also have a problem with this judge's ruling, but for different reasons. And it very well may be that I don't know enough about this judge's rulings to be able to say definitively, but I find it concerning. And then this is talking about the plaintiff's lawyers in Kadri v. Meta argued that Meta's use of pirated material was a major issue, but the judge did not focus on the claim like Alsup did, instead noting that the parties would have a Zoom conference to discuss how to handle the piracy claims. So basically, you have two different judges that are focusing on two different components of the law, with one focusing on the piracy itself as a concern, and the other one focusing on the market impact. And literally, the judge in the Meta case basically called out Alsup, the judge in the Anthropic case, for air quote, brushing aside the importance of market harm in his fair use ruling by focusing on whether the use of the work was transformative, which I kind of stand this judge a little bit. Like just bitch slap that fucker. I'm just saying. That's chef's kiss. I love that. That was just like, I just, but I think it's interesting because, like, I think it's important to recognize that you can't really take a fair use argument and just break it down into a single component and then say it is fair use or it's not fair use based upon this one specific component, because it does have four. And you can just easily say, okay, this one component is not relevant because it doesn't apply in this case. But you have to actually go through all of the components of it in order to say whether or not it's fair use, which is one of the problems I have with the Alsop case, the Anthropic case specifically, because it's just completely ignoring market harm entirely in favor of just saying it's transformative, so it's fine. No, that's not how that works. It's a very strange one, and I kind of hope that they appeal that, honestly, because it is kind of a sus thing. All right. Talking about whether or not it's transformative, it's not a substitute for but rather something new. They also assess whether the new work causes market harm or hurts the original art financially. It's notable that and this is another quote, it's notable that he disagreed, sharply but respectfully, with Judge Alsop on the market dilution theory, says James Grimmelman, a professor of digital and internet law at Cornell University. Other legal experts highlighted the meta judge's focus on market harm too, noting that it should shape how future AI copyright cases are argued. And this is another quote, "We haven't seen the last of this novel market dilution theory," says Cardoso law professor Jacob Nodi Victor. "That might change the game in the other cases or in future litigation." And this is the part I just find so very weird, is that like people that are advocates for generative AI are basically saying Judge Chambers' ruling today, bottom line, that training generative AI models on copyrighted material is clearly transformative if absent proven market harm is fair use. I don't think he said that. Like, or I don't think they said that. Like, they basically said that the there wasn't enough evidence one way or another to just make a decision, and that makes sense. If you don't provide the market harm, I'm not sure that you can make a ruling unless you do confront all the avenues of fair use. So that kind of makes sense that and like this comes back to the fact that this is a summary judgment. There wasn't any arguments really. It was just presenting each of your takes on this, and then deciding, because there's just not enough evidence. There's not the right arguments being made. Okay. And this person is saying he didn't like coming to that conclusion for reasons he details, and which with respect to market harm, are utterly out of step with established fair use precedent. Market dilution is malarkey. I'm just gonna go back to this. Like, this entire section is based basically on how it affects the market for the original work. Market dilution does apply. Like, it doesn't specify that it has to be you selling that work. It doesn't even say that. There's nothing in copyright law that says that it's just about using that work in competition. Like, this is just not at all what that says. So I think it's weird to say market dilution is malarkey. And the thing is, I think it's important to recognize that we're dealing with a very unique situation that probably was never intended with copyright law. It never anticipated something like this. So of course it's going to be hard to actually make any sort of rulings. And obviously the easiest thing would be to just add an act on the federal level that clarifies how this works. But I don't see that happening anytime soon. Here it says, and that's the catch. The judge took pains to stress that his ruling was based on the specific set of facts in the case, leaving the door open for other authors to sue Meta for copyright infringement in the future. And this is a quote, "In many circumstances, it will be illegal to copy copyrighted protected works to train generative AI models without permission," he wrote, "which means that the companies avoid liability for copyright infringement will generally need to pay copyright holders for a right to use their materials. Well, this is like pretty much universally true. I think it's important to recognize that getting permission from copyright holders to use their work is the only guaranteed way to ensure that you are actually safe, because fair use, like I said before, is a legal argument. It's a defense. Which means if you've already gotten to the point where you're making a fair use argument, it's already too late because you're already in court. So, just saying. And this is a quote from a Matthew Sag, a professor of law and artificial intelligence at Emory University, which, apologies if I said that name wrong. On the surface, this looks like a win for the AI industry. However, the court does take very seriously the idea that AI models trained on plaintiffs' books could flood the market with endless amounts of images, songs, articles, books, and more, thereby harming the market for the original works. He probably takes it more seriously than the plaintiffs did, given that they did not put any evidence on this issue. I have never seen a ruling where a judge lamented the failure of the plaintiffs to argue their case quite like this one. And this is one of the things I thought was kind of interesting when I was reading these articles, is the fact that the judge was wanted so much to like rule in their favor, and he basically like delineated out a course of action for someone to file a lawsuit and win in front of him. Like, you need to make this argument, and you need to provide this evidence, and I will rule in favor. Hardcore, no ifs, ands, or buts about it. Like, that's just what is going to happen. And it says here, this is the plaintiff's attorney at, I'm not even going to try to pronounce that law firm, said in a statement, the court ruled that AI companies that feed copyrighted protected works into their models without getting permission from the copyright holders or paying for them are generally violating the law. Yet despite the undisputed record of Meta's historically unprecedented pirating of copyrighted works, the court ruled in Meta's favor. We respectfully disagree with that conclusion. Now, I will say, not giving the authors and their lawyers the opportunity to amend their complaint or to argue this in more detail in court was probably the wrong choice. Like I said, this is a summary judgment, so it never went to trial. So there wasn't really any opportunity for discovery. There was no opportunity for like I could definitely see this being a situation where the case was dismissed because they didn't provide enough to actually do this. I think it's a little weird that they did a summary judgment, honestly. And yeah, this is from Meta. We appreciate today's decision from the court. Open source AI models are powerful, transformative innovations, productivity, and creativity for individuals. Oh God. Okay. I can't talk. Open source AI models are powering transformative innovations, productivity, and creativity for individuals and companies, and fair use of copyright material is a vital legal framework for building this transformative technology. I don't think any of that's true. Honestly, there have been instances that I have seen online where you're getting clear examples that they're not creative, that companies that are using them are regretting doing so, like companies that have like fired people in order to implement generative AI technology, like customer support and stuff like that, regretting it afterwards because it was actually making their customer support worse. Sorry, I'm a little thirsty. And I've definitely seen some examples where it's pretty obvious that these generative AI programs are just not very good at being creative. First off, because they're just basically generating stuff that's already existed in the world. I mean, they're mixing it up and changing it around, but they're not really thinking it through. For example, there was a video by Zoe B where she had an AI write her script, and it was very awful. Apparently, the AI that was being used in that instance could only remember the last 1,500 words. So it got increasingly unhinged as the video went on because it had no idea what it had already said. So it wasn't capable of framing an argument in that regard. So, like, for very short pieces, it probably would sound fairly sensible. But once you got into longer segments, it got increasingly unhinged. So, even if you could claim creativity for individuals and companies, it's got a very limited capacity. I don't know if there's what the limitations on its memory for various AI programs are, but it is something that's kind of an issue. Then, see, plaintiffs in other AI cases are paying close attention to the outcome. We're disappointed in the decision, but only in part, says Mary Rasenberg. Sorry, names are weird. The CEO for the Officers Guild, which I had mentioned earlier that they're doing a case, which is suing OpenAI in its own copyright infringement case, noting that this judge kept the ruling deliberately narrow. In the grand scheme of things, and this is another quote, this is from the judge, the consequences of this ruling are limited. This is not a class action, so the rulings only affect the rights of these 13 authors, not the countless others whose works Meta used to train its models. And as should now be clear, this ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. So yeah, it's just kind of funny that anyone would look at this case and think this is good for generative AI. Honestly, it seems like it's something that is very bad for generative AI because it is creating a very specific framework for how to formulate cases in the future, and even how to formulate some of the cases that exist now, because very few of them are, working from the transformative narrative. There are some cases that are going through, like the Disney and Universal cases, where they're arguing that it's basically outputting copyrighted material. And honestly, I watched a video by Legal Eagle that talked about that specific thing and showed some of the images that they used from their lawsuit, and oh my god, if I was shown those two if some of these images shown side by side, if I was shown the two of them, I honestly would not be able to know the difference. I wouldn't know which one was the one from Disney or Universal and which one was the one from Midjourney, which is in a situation where the transformative argument is really important, because I think we can argue there is no element of it being transformative. It's not. Like, if you're literally having it that you can't tell the difference between a screenshot from the movie and an image generated by Midjourney, then it's not transformative. I mean, there's some small little differences, but if you don't know the difference, if you don't know which one's which, you wouldn't know. You just wouldn't. Anyway, moving on. I don't think there's much I wanted to talk about from this article. I think what for this one, mainly I wanted to highlight the fact that this title was so deceptive, because it doesn't highlight the fact that this case is not a good win for AI. That this case is actually could potentially be a death knell for AI. That the fact that this judge was basically creating an entire framework for how to do cases in the future and have them win is kind of a major problem for AI. And it's kind of telling that it doesn't even talk about that. And this does talk about that the authors had not presented enough evidence that the technology's company's AI would cause market delusion by flooding the market with works similar to theirs. It mentions that, but it still calls it a win for Meta. And like, what else is there in here? And like, it still, this rule does not stand for the opposite. Like, it's saying things like this, but it's also calling it a win. And the judge dismissed as nonsense Meta's claim that the public interest would be badly disturbed if AI developers were blocked from using copyrighted protected works freely. Like, it's saying this type of stuff, but then saying this is a win for Meta. Like, it's inherently deceptive. And here he says, no matter how transformative LLM training may be, it's hard to imagine that it can be fair use to use copyrighted books to develop a tool to make billions or trillions of dollars while enabling the creation of a potentially endless stream of competing works that could significantly harm the market for those books. This is literally what the judge is saying, and they're saying this in their article, and then this is their title here. Meta wins AI copyright lawsuit as U.S. judge rules against authors. What are you doing? Like, honestly, Guardian, like, clearly they're just simping for AI so much in this headline, and they're hoping no one reads beneath, actually reads the article, because the article doesn't say that. Like, the article doesn't say that at all. It very much highlights the fact that this is not a good win for AI, that that there is decidedly and I don't even think this one, I don't think it says it's a summary judgment. This is a ruling, a decision. That I don't know that I remember seeing anything about it being a summary judgment, so they don't even clarify that this is a summary judgment, that this didn't go to court. So it's making it deceptive again by not making it clear that no, they didn't argue their cases. This is not how that worked. So, like I said, that was one of the things that I noticed when I started looking into this, was just the fact that the headlines were kind of weird. And like, some of them were clearly stating like it's a win, but, and others were saying that, there's serious implications for the ruling when it comes to how these cases will be handled in the future. But some of them are just doing these weirdly kind of cringy, clickbaity, probably simping for AI pretty hard headlines, while simultaneously having that their author, like Dan Milmo here in this case, is kind of saying the exact opposite. And so now then we have this is says globallegalpost.com. Again, all of the links are in the description of the video. But I wanted to get into this as kind of like a transition, I guess, between the Meta case and the Anthropic case. So this was an article titled "Anthropic Meta Fair Use Rulings in AI Training Expose Judicial Split on Market Harms." So, quoting here, two recent opinions, Judge Alsup's ruling in Bart's v. Anthropic PBC and Judge, I can't pronounce that, decision in Kadri v. Meta Platforms, illustrate how judicial perspectives can lead to differing analyses of fair use, even when the outcomes appear aligned. And like I said, this is something that's pretty common as a rule when it comes to fair use arguments, that they do have a tendency of being pretty flexible, shall we say. And this says like fair use is an affirmative defense to copyright infringement, assessing under 4 factors, which we already went over. Both cases involve author plaintiffs whose books were copied to train large language models. Each defendant used unauthorized digital copies from shadow libraries. While both courts ultimately found fair use, the reasoning diverged. Both judges found that training on lawfully acquired materials is transformative, favoring factor 1, Now, yeah, training, I can see where that's transformative, but transformative does not necessarily mean that it's fair use. I think that's important to clarify. That's just one of many components, and that's one of the problems I have with the Anthropic case specifically, is that it focuses too much on transformative and just basically ignores everything else from what I can tell. And acknowledging that the highly creative nature of novels weighed against fair use under factor 2. Also true. That's something I already pointed out. Even though entire books were used, another one of the components, both judges ruled that copying the full works was reasonable given L&M training requirements, thus favoring factor 3. I don't like this right here at all, because this is making an excuse stating that, oh, because AI has to do it, it must be right, which doesn't work as a legal argument at all. You know, if that's like saying, oh, because you have to copy the entire book in order to pirate it, that's legal. What? That doesn't make any sense. Like if you adapt that into any sort of other argument, it doesn't make any sense, which is why I don't really like that. The courts differed, however, in their treatment of pirated books, leaving the impact of pirating copyrighted works for AI training uncertain, which is also, not gonna lie, some of the recent things I've heard about when it comes to court cases on the federal level are also going to be making this a little bit complicated, because there are situations where court cases are being deemed by the Supreme Court to not be applicable universally in the United States, even though they're supposed to be like universal like bans. Essentially, I can't remember the word for it off the top of my head, but basically stating that like federal judges, federal courts are not allowed to make rulings that would affect like that would stop certain things from happening on a federal level. It only applies in their district, which kind of defeats the purpose of being a federal judge. Just saying. But I think it's important to point that out, that we are having some very weird things happening with like the Supreme Court right now, which could make it even more uncertain when it comes to whether or not this training data is lawful or not, this training practices is lawful or not, just because we could end up having rulings that basically state, oh, well, it's legal in this specific district in Texas, but it's not legal in Nebraska because it's a different federal judge district or something like that, which is kind of messed up. Not gonna lie. Alsop distinguished between pirated and legally acquired books. He ruled that using purchased books for training could qualify as fair use, but held that Anthropic's creation of a general purpose library using pirated books could not. Which is kind of weird. Not gonna lie. Like I do think like there is such a thing as like you are allowed to scan your own copies of your books. So if I have, so say I have this copy of Save the Cat Writes a Novel. If I wanted to make scans of it for my own personal use, whether it's just random pages that I find useful or scanning the entire book so that I have access to it on the go, technically speaking, I can do that. According to these rulings and previous rulings, apparently you can do that, but it's for personal use is kind of the important factor, or it's like it's okay for personal use. Apparently it's also okay for like nonprofit and non-commercial uses, but that's where things I feel like fall apart with this narrative with which I just realized that I probably should have put my screens on like the windows I have in opposite directions, because like the way I have this set up, my my browser window is over here, but it shows up on this side on on the live stream, so that I wasn't thinking that through. But it kind of is a little concerning, because they're yes, they were legally acquired books. Yes, it's legal to scan them and create a database. But that still means that the way you use the stuff has to fall under fair use, which is why I feel this is kind of weird. Like, there are very specific restrictions with book scanning and destructive book scanning and stuff. And like, that was the reason that the like was, I think it was a 2013 Google court case actually ruled the way it did, because it was a non-commercial use, and like there was all sorts of reasons why they ruled that way. But the whole point was that it didn't compete with the original source. It actually provided links to those books. It only provided little excerpts of them. It allowed you to search them to identify sources to utilize, things like that. It was actually a very useful database. But key point is it wasn't having an impact on the market. And like, this ruling for ALSUP was, it just completely ignored a massive portion of the process. But I think it's also interesting. I also viewed the initial acquisition of the training materials as a separate act from using the materials in training, and found that storing pirated books in a central library was inherently and irredeemably infringing, which I thought was kind of interesting, because I'm going to come back to this. Fair use is a legal doctrine that promotes freedom of expression. The unlicensed use of copyrighted protected works in certain circumstances. All right, so use. So they're basically, the ALSUP judge was saying that there's a difference between how it's like its initial use, as in it's being scanned, and then its later use, as in training models. I kind of think that's might be okay, but I also think it might be a major problem. And it feels like it's being very nitpicky, and it kind of makes me wonder, like, I don't know. It feels very weird, but I think it's also important to recognize that the Anthropic case is still going through the courts. This was an initial ruling on specifically the component related to destructive scanning of print books. So that ruling that case is not finished. So the judge in the Meta case, by contrast, was less concerned with how Meta obtained the books. He viewed all copies used by Meta as a part of a transformative process, regardless of how they were acquired. Which I honestly don't even know how to think about this. Like, going back to the whole transformative thing, transformative uses are those that add something new with a further purpose or different character, and do not substitute for the original work. I don't know how to think about that. Like, I feel like neither of these judges like got it right. I think they're trying, but I feel like they're just like inherently missing the mark. Like, for example, I do kind of get with the Anthropic case with ALSUP, looking specifically at that as like having it that pirating copies is a separate issue to like using those copies for using both legally and illegally acquired copies for other purposes. So I think this is interesting, because essentially what this means is that the Anthropic case has not ruled on anything AI related. And I think it's kind of interesting that the Meta judge actually kind of ruled on the transformative process, saying that even using copies that were acquired illegally, like they were not acquired via approved, authorized um, avenues was okay, which is kind of interesting. And I don't know how you can call that transformative though. Like, how is that transformative? How is downloading pirated copies transformative? Just saying. Like, even if you like combine that all together, and I think this is interesting because it is two very different approaches. So in the Alsop case, for example, in the Anthropic case, they're specifically trying to break apart the case into components that are not specific to AI and are specific to AI. Versus the meta judge did not do that. So I don't know what to think there. And I guess that might. And what's interesting is like that might be why, like AI supporters, see this as a win. Which I didn't really notice this before. Before I went live, because, but I also think it's interesting that in spite of this, which it makes me wonder, like, what is the nitty gritty of this, because the meta judge specifically stated that in most cases this would be illegal. In most cases, you would need to get permission. You would need to pay for use, and yet I'm seeing this, which kind of contradicts a little bit. And I think this comes down to, I don't think this was ever the intention of that judge to draw that conclusion. And I think it's more that he focused very specifically on the market harm part of the fair use equation and just basically ignored this part entirely, which again, I have a problem with, because it's not something you can just ignore one component and focus on another. It's not. That's not the whole point. I mean, obviously, the spirit of the law is that we're trying to protect creators from like being able to protect their livelihoods. And I think that's an important component here. But it's just weird. And here it says both judges considered three types of potential harm: the development of licensing market for training data, reproduction of the original work, and dilution from AI generated substitutes. Both courts dismissed the licensing market argument, finding it not to be cognizable. I can't. I'm not sure where that would have gone at all. They also rejected the claim that LLMs reproduced copyrighted works directly. Meta's models, for example, could not reproduce more than 50 words of a book. However, the third, and I think, like in these specific instances, yes. But there is instances of like image generators that have generated copyrighted works. Meta's model, for example, could not produce more than. However, the third column, market dilution, exposed the biggest split. Alsop was dismissive, likening the complaint to fears that teaching children to write might produce competition. The meta judge disagreed, calling the risk of LLM generated substitutes unprecedented. He found for meta unfair use primarily because the plaintiffs failed to argue or present sufficient evidence of market harm. So, like, I don't think either of these judges have it right, from what I can tell. It seems like they're both kind of missing the mark entirely. And I'm going to move on to the next article. Anthropic did not breach copyright when training AI in books without permission. Court rules. Again, this is really deceptive headline. I'm just going to say this because that's not what they ruled. They ruled on very specifically. A U.S. judge has ruled that a tech company's use of books to train its artificial intelligence system without permission of the authors did not breach copyright law. This was a very, like, they were trying to get a nice little headline here. But I think it's important to recognize that they're specifically talking about print books and specifically destructive book scanning, which is something that has precedent. And it's specifically the fact that the judge in the Anthropic case is splitting the acquisition and development of a database from the actual AI training So he's looking at this in two very different contexts, right? Um, and so he looked at specifically creating this database is not in and of itself harmful. Now, I would be interested to see how this presents in the future, because if he is splitting this up, it is still possible that the use of the database, even the one from legally acquired books and legally scanned books, could still violate fair use if he's using it in a way, if they're using it in a way that affects the market or is not acceptable. And keep in mind that the court case that this precedent is based on is it's fairly specific, and it's a best case scenario essentially. And I also want to point out that like Alsop added, however, that Anthropic's copying and storage of more than 7 million pirated books in a central library infringed the author's copyrights and was not fair use. So, although the company later bought millions of print books as well, the judge has ordered a trial for December to determine how much Anthropic owes for the infringement. So, Anthropic is going to be in trouble for millions of books. So, and like here it says US copyright law says that willful copyright infringement can result in damages of up to $150,000 per work. So I don't think they're going to owe that much, but it's going to be a lot. Because it's basically already ruled that that was legal. So just on the central library of pirated books, they're going to be in up shit's creek, frankly. It does give a possible avenue unless Alsop rules in the plaintiff's favor with regard to the actual training data and output and market dilution, which I don't think is likely. I don't know what all is going forward. It sounds like this judge didn't hold a lot of regard for the whole market dilution narrative. I think that's one of the things I was saying. Yeah, Alsop was dismissive, likening the complaint to fears that teaching children to write might produce competition, which is a weird narrative because honestly, I don't feel like programs like ChatGPT and stuff can really rise above the level of toddler when it comes to some of this stuff. But I yeah, I don't know that, like, because of the nature of these cases and because of the fact that it is copyright, I don't like this judge didn't really try very hard. Relied very heavily on precedent, wasn't trying to rock the boat, and very much focused on the specific things that he knew he could get away with. That yes, there is precedent for scanning of print books for personal use, which I think is important to note that. And I don't know, like, I'd be interested consistent of copyright person. What is like, and this is one of the things I don't know is what is the, and this is something I would be interested in knowing, which I don't know at the moment, is just that what all is moving forward. I know that in this case, what is moving forward is the trial regarding the 7 million pirated books with Anthropic. But I think it's I don't know. It's just it seems very short-sighted, and quite frankly, it doesn't really fit with the narrative. So like here I'm going to pull up the this is from Dunner Law, and this is talking about the ruling in Google Books case could have huge impact on publishers and authors. It was 2004. 2004, Google began working with major research libraries to create digital copies of books in their collections. Google's intent was to create a searchable online database of those books by digitally scanning copyrighted books without permission of rights holders. Google ran afoul of the exclusive rights of reproduction. As a result, authors and publishers sued Google in 2005 for copyright infringement. Google defended its actions based on fair use doctrine, which shield attempts to settle the matter between uh ruling in Google's favor, the judge determined that Google's actions fell reasonably within the fair use doctrine. Specifically, the judge held that the Google's use scanning of the books was transformative because the underlying books were being used for a new purpose, namely a searchable online database. And like this is like I think this is something that's important to recognize. The act of scanning the books itself is not transformative. That's not what this ruled. And that's something I feel like it feels like that was getting missed in a lot of the things I was reading. It was like calling it scanning the books is transformative. I saw that somewhere. I don't remember where anymore. But I swear to God, I saw something say that like scanning the books is transformative, and I don't know. I'm not going to worry about it too much, but like it's important to recognize that like the point that's transformative is creating a database of scanned books. The database itself is the output. Um, and I think that's where things are kind of problematic because this is a transformative use of something falls within fair use doctrine. Moreover, the judge felt that the public benefits of creating a large-scale searchable online database of scanned books outweighed any potential harm to the rights holders. According to the judge, such benefits include providing new and efficient ways of readers and researchers to find books, facilitating text mining or large-scale research purposes, expanding access to books for those constituents not served by large research libraries, or preserving old and out-of-print books, and benefiting authors and publishers by providing links to sellers of the books. But key point. These were the things that were important. Google only made snippets of each book as a large to large available for viewing. There's no evidence that Google directly commercialized the books by selling entire digital copies, or that they sold snippets to the database, or that Google made money by running advertisements on pages such snippets were located on. Point being, one of the important components in this was the fact that Google wasn't making money on this. Anthropic is. So, an important element to recognize with regard to this Google case was the fact that one, they weren't making money. Two, it was transformative because they were creating a database rather than creating books. And three, it actually could benefit authors and publishers because it provided links to sellers of the books. So like, and there was a general overarching good involved, you know? It's from archive.org, which is an organization that creates an archive of books, if I remember correctly. And this is calling it a big win for libraries and the future of public access to knowledge, which I think is a little weird because let's be honest, the only ruling that was done here was basically establishing, it was just reinforcing precedent. This precedent already existed in 2005 with the Google case. So this is not anything new. Finding the company's use of purchase to train its AI model qualified as fair use. While the case centered on emerging AI technologies, the implications of the ruling reached much further, especially for institutions that depend on fair use to preserve and provide access to information. The court sided with Anthropic on this point, holding that the company's format change from, and this was one of the things that bothered me. The court sided with Anthropic on this point, holding that the company's format change from print library copies to a digital library copies are transformative under fair use factor 1. No, they are not. This is not actually utilizing this ruling. This ruling stated that transforming it from a book to a database was transformative. This is trying to claim, and this is a quote, by the way, they're quoting something, that transforming from a print library to a digital library was transformative, which I would argue is not the case. I don't understand how that can possibly be the case, frankly, because that starts leaning into the possibility that you could just do whatever you want with it. And like, keep in mind that it's specifically focused on how the database is how the library is being created. It also ruled that using those digital copies to train an AI model was a transformative use, again qualifying as fair use under US law. And again, this is not how fair use doctrine works. It's not, oh, it's transformative, so it's automatically okay. That's not how that works. Like, this is really weird. And this is the part that I keep seeing. Like, you have with the Meta case where, completely focused on the market harm, and then on this case completely focused on whether or not it's transformative. But that's not how fair use has ever worked. Like, fair use has always been a situation where you have to look at all of the individual components, all 4 of them, and then like balancing one versus the other and deciding whether one or more is even relevant, coming to a conclusion. These judges are not doing that. And I think this is a major problem for copyright. I don't think either of these cases are likely to be situations where they set a precedent that will hold for the future in any lasting way. It seems like even in the case of the Meta case, where it could be more concerning, like in each of these instances, I don't feel like a real true precedent has been established. In the Anthropic case, it feels like the main thing that they really ruled on was just the so far it was just the they just were kind of dismissive for the most part. And I think, I mean, like, claiming that it's transformative is not really a relevant argument. It's like training, like, I would say that training an AI model on copyrighted work is transformative, but that doesn't mean it's fair use. And that's one of the things I have a problem with this situation, is like, they're like, okay, yes, it's transformative, or yes, it's diluting the market, it has a market harm, and that's the thing that makes it fair use or not fair use. No, just no. Oh my god, no. That's not how that works. You have to look at everything, not just one component of fair use. You have to look at all of it as a comprehensive whole and then make a ruling based on that. And neither of these judges, I guess technically they are still lawyers, but neither of these judges are doing that. They're actually just like very specifically picking a specific thing. And the thing is, by doing that, they're actually opening things up for further investigation and further lawsuits, because I don't think anyone would claim that training an AI model is not transformative. It's clearly transformative. You're clearly putting in one thing and getting out something else. You're using this to create a generative AI model. That's transformative. That doesn't mean it's fair use. Just saying. That is transformative. That doesn't mean it's fair use. Because like I said, going back all the way over here, there are 4 components. There is purpose and character of use. So whether it's commercial, hey, guess what? These are commercial uses. So that makes it less likely to be fair use. Nature of the copyrighted work. Oh, look, these are novels and stuff. Makes it less likely to be fair use. Amount and substantiality of the portion used in relation to the copyrighted work as a whole. Oh, look, They're using all of it. It's less likely to be fair use. The effect of the use of the potential market or the value of the copyrighted work. Oh, look, it dilutes the market. It's less likely to be. What are we doing here? Like, yes, I get that it's. Yes, I get that transformative are more likely to be considered fair, but more likely. Like, more likely. Not definitive. More likely. Also, what are you doing? Just saying. Get your head out of your ass and learn how words work. Just saying. Now, this is saying this part of the ruling strongly, going back to this article, sorry, a little bit aggressive, maybe. There. This part of the ruling strongly echoes previous landmark decisions, especially Authors Guild v. Google, which is the one I was referencing, which upheld the legality of digitizing books for search and analysis. But again, and it explicitly cited the Google Books case as supporting precedent. But again, totally different purpose. And I think that this, like, just because there is a precedent doesn't necessarily mean that that still makes this legal. And I would argue that Alsop's conclusions are inherently problematic because it ignores significant portions of fair use in order to come to that conclusion, focusing only on a portion of bullet point number 1 and ignoring other components of bullet point number 1. Because, like, let's be real here. Purpose and character of the use, including whether the use is a commercial nature or is a non-profit educational purposes. Anthropic is not nonprofit. It's not educational. It is a commercial. It's not nonprofit. It's not educational. It is a commercial use. It is transformative. It's leaning towards the okay in this point, at least. But like, if you just doing it as bullet points, it is leaning more towards the fair use on this specific point. But it's ignoring everything else. Like, just saying. The fact that these lawyers are doing this is just irritating me because this is not how the law is supposed to work. And this is something that's kind of a problem across the board. I feel like I watch a lot of Legal Eagle, so I recognize how much the legal system in my country, in the United States, is on fire at the moment. There's so many absolutely terrible rulings that are happening right now, and this is definitely one of them. But I do think even the wins that they're purportedly getting are extremely limited in scope and sometimes only limited to the case in question. Like, I don't think, like, the Meta case, for example, that was a preliminary what do you call it? Summary judgment. Thank you. That was a summary judgment. Okay. Which means that it's not going to probably have as much weight as future cases where they actually went to trial, because nobody had an opportunity to really do much with the case. They just presented their initial arguments and the judge ruled. So that's not really very useful from a precedent perspective, because that's very easy for, I think, for a judge to dismiss. And again, I'm not a lawyer, so take this with a grain of salt, but it didn't go to trial. So I'm not even sure if that can be used as a precedent. I don't know. I don't know how that stuff works, but I do know that it didn't have, this didn't get argued out a lot. This was just the impressions of a given judge and what this judge decided to, on this specific case. And it's just not. Um, Going back to the article, while we believe the ruling is headed in the right direction, recognizing both format shifting and transformative use, the court factored in destruction of the original physical books as part of the digitization process, a limitation we believe could be harmful if broadly applied to libraries and archives. Yeah, absolutely. Um, there are absolutely situations where libraries, for example, and this is not as much of an issue, obviously, with older books that are outside of copyright, but you know, you may absolutely, because of how much time it takes for copyright to actually expire in this country, you could absolutely have books that are absolutely falling apart, and you want to preserve them because they're out of print. The author is dead. But it's still under copyright. Nobody can print new books of them, and if you don't want to destroy the original, you want to preserve it, but you also want to make scans to preserve it in case something did happen to the original. So I can absolutely see where this would be harmful to copyright as a rule, and for archiving purposes as well. And honestly, I don't know how to think about that. um I think I think there is a great deal of opportunity for harm if with what the Anthropic ruling did. I mean, obviously, this is an organization that does archiving of books, so that's where their concern is how that's going to affect their specific situation. I do think also that by saying it's okay to destroy the books, you're also making it so that you don't have to have proof that you had the books in the first place. So, like, this is a weird line to make, because realistically speaking, then you don't have any proof that you had the book in the first place. Like, where did you get these scans? You don't know, because they're destroyed. They got thrown in the trash. Maybe even burned. Because why not? So I do think this is a very strange thing to emphasize, and I can absolutely see where it would be harmful. I also see, like, in the original ruling for Google, it very much focused on the end result as to why it was okay to do these scans. Um, and this did not. It didn't care about the end result. It actually was very dismissive. Um, and it completely ignored certain components of the original ruling. So, some of them being the fact that it was a nonprofit, that it had a very different purpose. But realistically speaking, um, while it's a different type of thing, like obviously generative AI programs are not the same thing as books, they're used to make books. So it's kind of weird to just say, oh, well, this is not in any way competition, so there's no market harm. Or, yeah, like that's very weird. And it's also very weird to just like inherently ignore all of the other components. Like, even if you say there's no market harm, which I don't think anyone can really argue that in any cohesive way, you still have all these other components. And pretty much all of this. Like, you're ignoring the fact that it's commercial, even though the Google thing was. I mean, it's like you're ignoring the fact that it was commercial, even though the Google thing was non commercial. You're ignoring the fact that the transformative nature was making it into a database, when you don't have that same element with the Anthropic case, because you're removing it from its output. You've separated it from its function. And that's a problem, I think. The fact that he did do that he separated it out from its function, means that it's making it so that essentially the process of scanning books, period, scanning print books, according to him, according to the judge in this case, is transformative. That's basically the argument he's making, because he's completely separated out the output, the purpose, what is being made. Because you have a library of books and you created another library of books, that's not transformative. You're just scanning it into another format of book, another format of library, which is not transformative. Now, if you were going to argue that, connecting those two things together and saying that it is transformative because, sorry, let me just make this clear. Okay, so he's distinguishing the destructive scanning of books and pirating copies as being, one is legal, one is illegal. But the problem is, the whole point of this ruling, the Google ruling that he uses as precedent for this, is that the creation of a database was a transformative process. Not the scanning of books. The scanning of books was part of the process, but it wasn't the outcome. The outcome was the essential component that made it fair use. Also, the fact that there was a public good. But the Anthropic judge is not saying that. He's separating it out entirely from its intended function, making it so that he's basically saying, well, I agree with this, but let's just ignore all of the relevant fair use components of this and just focus specifically on the scanning. Which to me is a major problem, because if that is used as fair use, as justification for fair use in the future, it would absolutely and utterly decimate copyright law. Because it would basically make it so that anyone, like, that you can do whatever you want with a book that you have a print copy and you scanned it. If you destructively, and like, say you duplicate this as much as possible. You buy a bunch of books, you scan them, you convert them to a new format, and you make them available. However you do. According to this ruling, if you use this as a precedent, it would be legal. Because he's separated it out completely from its intended purpose. Additionally, because he's basically completely ignored the fact that the original ruling was at least partially based on the fact that it was a non-profit, good of the people, public good type of thing. That was an element in the fair use argument for this case. He ignored that. He ignored the fact that it was a non-commercial use. He ignored the fact that the transformative part was not the scanning, because the underlying books, like specifically, the judge held that Google's scanning of the books was transformative because the underlying books were being used for a new purpose, namely a searchable online database. But like I said, the problem is Anthropic is completely separating the use from the copyright claim, from the fair use argument, which I think is very dangerous. I think that could have devastating consequences for the publishing industry. And I think it could absolutely result in a situation where people stop producing print books because it's not safe to do so. Because because if this ends up being the way that generative AI trains their stuff in the future, the only way to keep our books out of those hands is just to not print books and just do ebooks. And I really have a problem with that. All right. And that's one of the things I think is weird. Like this article saying this decision reinforces the idea that copying for non-commercial transformative purposes, like making a book searchable, training an AI, or preserving web pages, can be lawful under fair use. That was never argued, and that's actually not what this says, because training an AI is not non-commercial. Anthropic is not a nonprofit. It's not an educational institution. It's not an academic endeavor. It is a for-profit company that makes hundreds of millions of dollars a month. Like, does Anthropic make money? I think it is. This is saying 115 million a month. Anthropic hits 3 billion in annualized revenue on business. I mean, like 61 billion post money evaluation, like 4 billion is listing here. Like this is a for-profit company. So trying to make a claim for non-commercial transformative purposes, that's not the argument that was made here. And this judge completely disregarded that part of fair use. Now, I get that this protection is essential for modern librarianship, but I I would be very concerned. And this is saying, as with the Google Books decision, it affirms the digitization for research, discovery, and technological advances can align with copyright law, not violate it. And the interesting thing is, like, I don't think that the things that I'm concerned about are the things that most people are when they look at these things. A lot of, for the most part, the fact that these rulings are extremely, they're not thorough, they're not great. You can't make a really good ruling that could work well as precedent without actually confronting all of the components of copyright law, all of the components of fair use. And that's where this one did do that. The Google Books case is a good example of fair use because it confronted all of these components. It is nonprofit, it is transformative. So, that covers this first one. It looked at this part, and I think a lot of, I get the impression that a lot of the stuff was not creative expressions, but rather stuff that's more technical in nature. So this was a database for searching books. Yeah, major research libraries. So that was another component of this ruling, is because it was that nature and the amount and substantiality of the portion used to relate to the copyrighted work as a whole. This was another component, because while they had access to the entire thing, they only showed snippets. They only showed whatever was relevant to the search that was created. That meant that they looked at this component. There was, and they specifically stated there was no evidence that Google was distributing whole works. They were only distributing snippets, and they weren't profiting from any whole works that they had scanned. This was another component that was brought up. And then the effect of the use upon the potential market or the value of the copyrighted work. This is another thing that they looked at in that ruling. They specifically looked at how this could potentially impact the market. And specifically, they highlighted the fact that it could benefit the authors and publishers because it actually provided links to where to buy these books. Meaning, the Google Books case was a really good example of how a case of fair use is argued and ruled on. These two cases are terrible. They're absolutely atrocious. Now, that being said, I understand why I don't understand why the Meta case wasn't just dismissed. Like, I don't know why it was a summary judgment. I I feel like the smarter thing would have just been to dismiss the case, and this is the reasons it's being dismissed, rather than, siding on Meta on anything. Um, so I do think that that was a problem. But I also recognize that that case has the potential to shape future cases or cases that are currently going through the system, because you can always amend your complaints, amend your arguments, and present from there. So that could absolutely just kind of reinforce the elements to which people are doing these cases. But I do think it's important to recognize that neither of these cases really focused on all the components of fair use. And as such, they don't really work the same way as the Google Books case when it comes to establishing precedent. They're actually terrible. They're honestly bad. And I I really hope that they just kind of get forgotten over time, because I don't think that they really do the things like for example in this situation they're talking about how this is a win for libraries, but I don't think it is. Like I said, if this actually ends up being any sort of a precedent and it actually starts driving change, the most likely change I can think of it driving is moving authors to focusing more on ebooks than print books, and maybe even stopping producing print books at all, because it's not safe to have print books looming out there, which would suck because lots of people like print books. I personally want to provide as many different formats as I can, and that's why I have ebooks and paperbacks and print books, and I don't have audiobooks, but that's because it's really expensive to produce them, and I don't make that much. I don't make like any money on my writing, honestly. It's essentially a negative value. So, um, I just can't justify the whole audiobook market for that reason, which is one of the reasons I do want to try to like at least record my own if I can, but it is very time consuming, and I'm still trying to figure out ways of making that work with my time. But I do think that if the Anthropic ruling does anything, I think the most likely thing it'll do is just encourage authors to stop producing print books entirely. And there's already a lot of authors that do that in the first place, but that would be tragic. It really would. I hope it doesn't happen. I hope that this ruling doesn't actually do like anything. Um, I I just saw this little thing here, and I'm like, oh my god, Chuck Tingle. Sorry, I have absolutely read Chuck Tingle, and he's awesome. Not gonna lie. Um, uh, sorry, I just completely derailed myself there. By just like noticing upcoming events on the side of this page. Oh my god. But I think that that is the biggest danger with the Anthropic case, is the fact that it could very well be used as a justification among authors to stop producing print books, because there are plenty of creators out there who are trying to find ways of preventing their stuff from being fed into generative AI training models. Examples being uh, um, AI poisoning. So this is something. Nightfall is one. I'm trying to remember what else there is. Um, but basically, what it is something that actually messes with the generative AI program's ability to learn from it. So like confusing it basically, and making it have a hard time identifying things because, well, yeah. Um, it's got questionable efficacy. There was a recent scientific journal article, for example, that um, actually somebody had created a program that could remove all this stuff, and they claimed it was to protect creators, but honestly, I have my doubts about that. But my point is that there are absolutely people who are trying to protect their stuff from ending up on being training data for generative AI. And so I could absolutely see people just deciding I'm not going to print books anymore because I don't want them to end up being fed into a generative AI. And if this is the conclusion that the companies come to, that you know pirated copies are bad, but we can get away with it if we do this destructive scanning thing, then that could very well be a situation we're dealing with. I also want to point out the fact that if that is true, then there is absolutely the possibility that we will start seeing a centralization of generative AI platforms, where companies like Google and Meta and Apple and stuff are honestly driving most of the innovation, because the smaller companies can't keep up. They can't afford to actually train their models, because they can't buy a whole bunch of books and then destructively scan them, and that's a lot of money to buy the books, and it's a lot, even if you're buying them at dirt cheap, like wholesale, still a lot of money. It's also still a lot of money to actually scan them, because I know from personal experience working in a laboratory that scanners that can handle this much scanning are very expensive. They cost thousands of dollars. They're not like your average flatbed you'll get from Office Depot. They are very expensive, and they break down a lot, honestly. You're using the living daylights out of them, and they, sorry about my dog. She's a little shit. But the point is, they are things that, and I also don't have a door in my office, so I can't block it out. But and I just forgot what I was saying. I completely forgot what I was saying. Oh my god. But I mean, my point is, we're going to be seeing situations where these AI models are going to be coming up with new approaches to try to avoid this. You're going to have it that if this is the conclusion that people come to, that some of the smaller AI models companies are just going to fall apart because they can't afford to do destructive scanning. It costs a lot of money to do it. And that's just something that a lot of these companies are probably not going to be able to afford. It's already expensive to train these models. It's already expensive to run these models. In fact, if I remember correctly, I think it was Claude, which is Anthropic. Claude is an Anthropic program. Pretty sure Claude, I'd seen something that even on their most expensive tier, which is like a couple $100 a month or something like that, they're not turning a profit on that. Like, people use it enough that it's actually losing them money. So, like, this is not cheap to run. It's not cheap to train. It's not cheap to build the databases. The only way that this is cheap is if they're pirating it, which I do think that is the one thing about the Anthropic ruling that is promising, is the fact that they're pointing out that the quick and easy way is still piracy. It's still copyright infringement. That's one thing that I would say is an advantage of that. But I don't think that that's a great win. And I feel like I had a much bigger conclusion, shall we say, when I first decided to do this video a couple days ago. Like, I had this idea, like, these cases are, sorry, I just like playing with the highlights. I had this like idea that these cases were just like nothing burgers, and people are blowing this out of proportion. I still think that there's components of it that are ridiculous. I think that calling them major wins, these are not major wins. They're really complicated. And I don't think that they will work really well as precedent for the reasons I pointed out with the Google Books case. The Google Books case is well thought out. It covers all of the components of fair use, and it made its decision based on that. Neither of these judges are doing that. They're basically ignoring large portions of fair use in order to come to their rulings. And in the Anthropic case, for example, the judge is basically I feel like the judge didn't want to actually try to make a ruling on whether training AI on copyrighted material is illegal. I think he wanted to pass that buck on to someone else, so he was very dismissive of it. Um, he was very dismissive of the market dilution claim, even though that is an essential component of fair use. Like, mar- whether the use is hurting the current market for the original work. It doesn't say that it has to be displacing sales of the original. And even then, displacing sales, what does that mean? Is that just having it that somebody else is making money from your book? Not necessarily. Like, I could see displacing sales is a weird thing. Um, and if you apply this to other forms of intellectual property, this starts getting a little bit more clear. Because when you talk about, say, for example, patents, we're not looking at whether or not um, they they're making the identical product. We're looking at whether or not portions of the patent that are relevant are hurting the market for the original item. And that can mean that you're looking at how different it is or how much it is negatively impacting the original object, the original, patent, the original patented item. And so displacing sales does not have to necessarily be displacing sales by buying from another person, but buying the same work. Um, and granted, that makes for a much harder argument when it comes to this effect upon the potential market for or value of the copyrighted work. But I think it's important to recognize that for the market dilution factor, when we live in a capitalist society, there's such a thing as supply and demand, which is generally the idea that the more supply there is, the less demand there is for any given work. As such, the more books are available, the less demand there is for your book. And I think that's an important thing to recognize when it comes to this case. Because, or in these cases, and generative AI in general, and this whole narrative of market dilution, is that it's not about just whether or not someone else is selling your work. It's about whether or not their use of your work actually hurts your bottom line. And that's not always as clear cut. And that is a lot harder to argue. And it's going to be a bitch to try to argue. And honestly, I'm not sure if any of these cases will be able to pull that off in any meaningful way with the way that the cases are being formulated right now. I honestly think that most likely, and this is going to be a really bitch of a case to try to file, but I feel like in order to make this work, there's a probability that it's likely going to have to be a massive class action lawsuit, and it's probably going to have to be against all of the major generative AI platforms for text. So, not just Anthropic or not just Meta, but all of them, and suing all of them at the same time. Because unless you have an author like isolated examples that specifically stated they used this platform and this platform pirated your specific work, it's kind of hard to like say that definitively. Um, and this is going to be something that's going to be really hard to argue in court. I don't think it's impossible. I think it's going to be hard, and I think it's going to absolutely have to be a class action lawsuit, hands down. There's no way around it. It's going to have to be a class action. Um, I think where I think right now the case that has the most potential to make a difference is going to be the Disney and Universal v. Midjourney case that's currently in the works. Now I've heard from like I think it was a Legal Eagle one that there's a good chance that this is going to be settled out of court. I actually kind of disagree. Like, I get why someone would say that, but I don't know that I necessarily agree with that. Largely because we all know how Disney is. Disney basically formulated copyright law in the United States to their benefit, specifically because they didn't want to lose access to Mickey Mouse and such. They wanted their very copyrighted stuff to be all about them, and they've been twisting and morphing and changing copyright law for a long time to extend that to the ridiculousness that it is now. But I also think that but there is like narratives about how Disney wants to use generative AI. So they wouldn't want to have this ruled in a bad way. They just want this to stop with Midjourney, for example. I don't agree, largely because I honestly think with the depth of their content that they have, they could probably create at the very least an image generator um just from all of their back content, all of their movies. Because if they were to take all of their movies and break them up into individual uh, frames and clear out all the funky stuff and clear out any funky stuff that exists, and just curate it a little bit to clean it up and then use that to train an generative AI, they'd probably have a pretty decent generative AI. I think I did a calculation of this and like I'm gonna pull it up. I'm gonna do this real quick. So say the average movie is 120 minutes, and 30 frames per second, and let's see, there. Really, come on. Yeah. Okay, so it says here, IMDb says as of 2024, has been 131 Disney movies. So let's do that. Times 131 is so right there, assuming any of that information is accurate, you have 400,071 600 frames. So almost 500,000 frames. And that's just assuming that any of the numbers I just quoted are accurate. Oh, here you go. This one is listing 748. So let's try that again. Times 748. Now we're at 2.7 million. So honestly, I think that could work. Like, I think that they could actually make a generative AI platform of their own using just the content that they have. So, and basically use that to generate all of the images, and then maybe create engines that are designed to create the next prompt based upon what the previous prompt had, or something like that. Just to make it like, and I mean, they would start with obviously images and then, progress from there. But my point is, they have the capacity potentially to make their own using all of their own copyrighted works. So it wouldn't really make sense It would actually make sense for them to try to drive uh, drive everyone else out, because most companies do not have access to this much copyrighted material. Most companies cannot access the depth of material that Disney can. Which means that if they did go to court for this and they established that this was copyright infringement, etc., Disney could benefit from it massively by generating their own model that was based entirely on their own copyrighted material. I don't think there's anybody else that has that type of depth of material. And it's so I do think actually it would be in Disney's best interest to get this on the books so that they can drive out the competition. And honestly, that seems like a very Disney thing to do. They're very litigious as a general rule, and I do think this would benefit them. I don't think it would hurt them to have this ruled in court, because there's like the question like 100% has to do with training on copyrighted material. And the simple fact is, if you own the copyrighted material, then it's not a copyright violation, you know? And that's just all there is to it. And that's the thing with Disney. Disney has a massive amount of copyrighted material. Like I said, depending on how they use it, they could absolutely do this. Do I think it would make for great content? Not even close. But I do think they could. And so I think that's right now, that's probably one of our highest hopes when it comes to a definitive ruling. Their court case seems to be pretty cut and dry, at least when it comes to but it's also important to recognize that their case is not, their case is also dependent on the fact that it is not being transformative. So it's not going to help in these LLMs that are creating transformative works, that they are not outputting copyrighted material in any decent capacity. Like I read something in one of these articles that it said that the one program could not generate more than about 50 words at a time of a copyrighted work. So, there is that. But I think in the grand scheme of things, this is just not a good example of something that could be used as precedent. I don't think it's going to have a significant impact in the long run. People might try to quote it in their future work, in their future arguments, but I don't think it will work very well. And like I said, it's because of this. This is a very strong case. This Google Books case is a very strong case because it touches on every single component of fair use, and neither of these cases do. They kind of are dismissive of some components, ignoring others entirely, and that's not a good example for precedent. Even though these were in court, and especially the Meta case, because it was a summary judgment, and so it never actually went to trial, it wasn't a good choice. It's just not going to it's not going to have a significant impact in the long run because it is a summary judgment. I think the Anthropic case could potentially have more impact just because it is moving forward like this. Like, to the best of my knowledge, I don't know what type of ruling it is, but my understanding is it's not a summary judgment. But also it is using this Google Books case as precedent, but it's cherry picking very, very much what it's focused on. So it's ignoring a lot of the reasons why this was ruled this way. And I'm hoping that that doesn't cause problems, but honestly, I also think that if that portion of the Anthropic case got appealed, that the argument was made that this didn't address all of the components of fair use, and as such was not a valid argument, then we could be seeing a very different ruling. Because like I said, it basically completely ignores some of the reasons why this case was the way it was just because, like I said, it touched on every single one of the components of fair use, and like I said, neither of these cases did, and as such, I I I'm gonna be keeping an eye out, and I don't know if I'm gonna be doing another video like this. I do plan on doing a video on escaping AI in the book industry. It's gonna be intended for both readers and authors, but I'm probably not gonna. I'm probably not going to address these types of cases again. There's plenty of other things I could be talking about, but I did want to highlight specifically that these cases are kind of being misconstrued, I feel like, in these headlines, and I think part of the reason, is because they have a very specific narrative they want to get across, but also the fact that these cases are not simple. They're not straightforward. They're not clear wins or losses, and I don't think they're going to set any precedents. I don't think they can, because they weren't well argued, they weren't well ruled on, and I mean that they weren't well ruled on. I do think that in the Meta case, this judge probably should have just thrown thrown it out and said, you didn't provide me enough evidence, you didn't provide the correct arguments, I can't rule on something that that you didn't make the appropriate arguments. And I think that, with the Anthropic case, I think there is a possibility that this portion of it could be appealed, just because it uses the Google case as a precedent, and the Google case did not say that. That was not the intention of the Google case. The intention of the Google, that was not the intention of the Google case. It completely ignores large sections of why this was ruled the way it was, to rule in the favor of Anthropic in that specific portion of the case. And that doesn't make any sense. And I don't think it's right. And like I said, I do think that portion could potentially be overruled. I don't know that the plaintiffs in this situation would want to do that, because they did get a partial victory, and I don't know if appealing one ruling would override the other. So yeah. Point being, judges do better, and also plaintiffs do better. Like, all of you, everyone, just do better. Like, this is really important stuff, and you guys are just fucking it up, like, left, right, and center. Like, the judges are fucking up, the lawyers are fucking it up, the plaintiffs are fucking it up. And because of that, the AI companies don't even have to try, honestly. Like, they could be like phoning this in, and like they might still be getting these air quote wins, because like this is just weird, not gonna lie. Anyway, I don't feel like I have a really important conclusion here. I think it's really just comes down to the fact that like these are being blown out of proportion. These are not the gotchas that these are not the gotchas that these places might want you to think. It's not concluding the things that they're claiming. It's just not simple, and I don't think it's gonna be precedent. I think anyone would be hard pressed to try to use any of these as precedents. Like I said, the Google ruling was a solid precedent. It covered all the components of fair use. These did not at all, and I'm hopeful that we will see some cases come through that will have more definitive rulings that we can actually be used as precedent, and might actually establish how AI training of copyrighted works will work into the future, but this is not it. It's just nothing. It's terrible. It's I will say that, the one component with the meta judge about highlighting how an argument for the market harm could be made. I think that that's an important component, but I also want to highlight the fact that any decent case arguing against fair use is going to do more than just claim market harm. It's got to look at all the components of fair use. It's got to look at all four of these. And yeah, you might have it that that it is transformative. But all of these have to be taken into consideration, not just one. And it's not just the effect on the market. It's not just how much was used. It's not just the nature of the copyrighted work, and it's not just the purpose and character, etc. It's all of them combined. That's what makes fair use, and that's what breaks fair use. And obviously, there is not any given formula, but focusing on one very specific component and being like, yeah, it's definitely fair use because it's transformative or because it's nonprofit. Sorry. That's not how that works. That's not how copyright works. Sorry, my throat just got really dry. Probably because I've been talking for 2 hours. But like, that's just not how fair use works. That's not how the argument works. It's not how you argue against it. You have to look at all of the components, and these cases didn't do that. Like, they just ignored it entirely. Like, the judge in the one case completely dismissed the market harm. The judge in the other case was just patently accepted that it was transformative without even considering the other components of bullet point 1. Like, transformative is not the only component here, but that's the only component they focused on. And even then, they were, again, very dismissive of it. And this is not a good way to do legal stuff. Now, that being said, I do think that, like I said, I do think that the meta case probably should have been just dismissed rather than having a summary judgment. I will say, if we're going to see a good case for or against AI, it's going to be one that looks at every single component of fair use and argues all of them. It's going to be something that looks at yes or no. Yes, all of it is used, and this is why. Or yes, all of it is used, but yes, there is an effect on the market, but, or yes, there is an effect on the market, and this is why you need to, like, this is the way in which we're going to see something happen, is when you actually have a case that argues everything. That's why the Google Books case was so important, because it argued all of these points. It ruled on all of these points, not just one, all of them. And even going into more detail on some of them, like this one includes a lot of different things. Yeah, this is a very nuanced point. And so, like, just focusing on the transformative component of it is essentially going to cause problems. That's just all there is to it. It's just going to cause problems. And I think, yeah, I think that's going to be my conclusion. If we want to have an actual case that has a definitive, that can be used as precedent, that can be used to change the way we look at generative AI when it comes to copyright law, I think it's going to have to cover all of these components. It's going to have to address it all. And if it doesn't address it all, it's going to leave loopholes in the legal framework to allow more cases to come through that argue on these cases. That was the reason that this is such a definitive ruling, is because it argued all of it. And until we have a case that argues all of it, and rules on all of it, we're not going, this is just going to be nothing burgers. It's just going to be a confused mess of contradicting rulings that go nowhere. So yeah, I'm hoping for a really big case, something probably something that is probably a class action lawsuit that really dives into this, so that we can actually have an actual ruling that's useful and helps us into the future. But that's all I've got for today, and I am planning to do I want to do another live stream. So it's been a while since the last time I was online. So I was originally contemplating my next video was going to be like before this. I wasn't intending to do this first, but I was intending to do a catching up live stream where I would probably be doing a Sims Let's Play while I talked about what I've been up to since the last time I did a video. I figure that's probably going to be the next thing I do. But if nothing else, I do have a book lunch party that I'm going to be doing on the 31st at 7 p.m. Eastern. And I plan on giving away some books. So if that's something that sounds interesting to you, then put it on your calendar. Anyway, stay tuned, subscribe, etc. And if you want to see more stuff from me, I tend to do a lot of stuff that's more, romance related, focusing on diverse representation. So, queer, BIPOC, neurodivergent, etc. I focus a lot on like alien romance and monster romance because that's the genres I like reading the most. But if any of that sounds interesting, feel free to, subscribe and hit the bell and stuff if you want to. But yeah, that's all I've got for today. I hope you enjoy your Sunday. And if you're watching this on replay and you got this far, I am impressed. You have probably gotten farther than any other person who has ever been on one of my streams. Not gonna lie. So if you are actually still here and you're on replay, I don't know what happened, but hey, welcome. I think you're my biggest fan.